Hello, everyone. Good morning. Good morning. How is everyone doing today? So, I am coming on Facebook, Instagram, and YouTube, and I have a really great topic today. And I really want to talk about this because this is an issue that has raised itself so many times in the past, and I want to talk about it and kind of go over a couple of things that you guys will find helpful. So I know my background is different now because we've moved to a new office. I'm so excited. It's still the same building, but it's a different suite. We're now in suite 209. So if you want to stop by, call, make an appointment, and come and see us in our new office for consultation, by the way. So good morning, everyone. So feel free to post in the comments where you're calling from so we know where you are. And we are in New Jersey, but we work with clients in all 50 states. And so I hope everyone is doing well today. And I'm just waiting for a couple more people to come in and I can get started. So for those who do not know me, my name is Ifeoma Odolami. I am an immigration lawyer in New Jersey. I'm also an immigrant. So I live the story, I live the experience some of you are just beginning to experience. Myself, my family, my mom, my siblings, all immigrants. None of us was born here, but we all have our United States. Well, my mom still has a green card, but the rest of us are citizens, except for my sister who does not live in the United States. So, what I want to talk about today, and I'll answer questions when I'm done. Hi, Ayodele, Lexington, Kentucky. Thank you for joining. So, I'm going to tell you this scenario, and then we'll walk through the information that you need to have. This is really, really, really important because there's nothing that hurts me more than having somebody make a mistake that jeopardizes their green card, right? Or not having the information to do something that could help them get a green card. So this is a fact pattern, right? Many years ago, I had a client who had applied for naturalization. Her father had applied for her. She got her green card through her father, but she was in her country. Then through the consular processing, she was able to get a green card and she came to the United States. And then she lived in the United States. 5 years after she got her green card, she applied for naturalization. And the naturalization took such a long time. Like the law requires them to respond within 120 days, but I think it took her like maybe a couple of years, 2 years maybe. So she came to me because she wasn't sure what was going on. She wanted to know why her naturalization had not been approved. So we did all the basic, checks, and finally what we found out was that when her father applied for her, she was in the category of single. So she was in F1, which is a United States citizen applying for a single unmarried child, right? Single unmarried, same thing. However, what happened was just before she left her country, she got married. Now, for some reason, that didn't come out before. She came through the customs, came out, no problem. Nobody knew about it. She didn't even know it was a problem until her naturalization, where she indicated that she was married and when she was married. So now it was clear that she was married before she came into the United States, which put her in a different category. And because of that, she should not have gotten a green card. Another case, and now we had to appeal. We filed a brief. We appealed the denial of naturalization because ultimately the naturalization was denied. And she was lucky that her green card was not revoked, that she was not given an NTA, which is a notice to appear in immigration court. Because what typically happens is she got the green card wrongly, unlawfully, right? And what happens typically is that that person will be served with a notice to appear in immigration court and deportation proceedings begin. Can you imagine that? Can you imagine that she could have gotten deported just because she got married without realizing that that was a problem for the category? And that's the reason why I want to talk about this, because another friend of mine, a lawyer friend, had the same issue. But in her case, her client is now in the immigration court. My client was lucky that they just denied the naturalization, but she has her green card, and that's that for her, right? Now, I've had several consultations where I remember one consultation where a mother was filing for her child, her son. He was single, and then he got married, and then the portal closed up because he was no longer in that category, and his priority date had been reached, which meant that it was time for him to come to the United States from his country, but they couldn't continue processing the case because now he was married and he was under a different category. So I'm going to go over these categories with you guys because it's really important that you don't make this mistake, which can really jeopardize your ability to stay in the United States and your ability to naturalize. And the funny thing is, a lot of times this mistake goes unnoticed until you apply for naturalization, which is the reason why I tell you that you're going to apply for naturalization. Don't assume you're just going to fill out the N400. Immigration attorneys have to screen you. We screen you to figure out how you got your green card, to make sure you got your green card lawfully. Because if you didn't get your green card lawfully, right, whether you knew it or you didn't know it, and you apply for naturalization, you put yourself in the danger of getting an NTA, a notice to appear, and being deported. So I'm going to share my screen. I've never done this before, so just pardon me. I don't know. I'm going to share the screen. So I want to show you the visa bulletin, which is something you guys should be familiar with if you are in the family-based immigration, well, any immigration process. So I hope this works out. Visa bulletin. All right, yeah, great. So can you guys see my screen? I hope you can. I'm so excited. This is my first time doing this and it works. So this is a visa bulletin, right? And I wanted to go over the family preferences. So first of all, I'm going to talk about the immediate relative, right? The immediate relatives are a U.S. citizen filing for their spouse, a U.S. citizen filing for their child under the age of 21, and a U.S. citizen who's at least 21 filing for their parents. These people are called immediate relatives, and there is no waiting for a priority date to file the petition. As soon as you file the petition, USCIS begins working on the case, or your case is being worked on. So other people in this preference category, which I have here, are in what they have to wait for their priority dates to be reached. So these are the preferences. Unmarried sons and daughters of U.S. citizens, they're F1, right? And then F2A is spouses and children of permanent residents. So children in immigration language is under the age of 21. So spouses and children under the age of 21 are F2A. Then F2B is unmarried sons and daughters, which is 21 years of age and older of permanent residents. And F3 is married sons and daughters of U.S. citizens, and F4 is brothers and sisters of adult U.S. citizens, adult 21 and over, okay? So these two dates basically give you, tell you when USCIS is going to work on this preference. Preference means that your priority date has to be reached before you can either adjust your status or move to the NVC stage for people who are in consular processing. So sometimes they use the final action date to determine what time. Sometimes they use the dates. For March, they're using dates for filing family sponsored. So we're going to focus on this. So for F1, they're working on cases that were submitted August 6, 2016. So if you submitted your case August 2020, your priority date has not been reached. So you want to keep checking this to see when your priority date is reached so that you know that your case is about to be, worked on. So F1, so what happened to that person? So F1 is they're working on cases from 2016. F2 is current. C means current. Now we have 3 different countries. Excuse me. I feel a sneeze coming. Okay, 3 different countries: China, India, Mexico, and Philippines. These countries have their own category because they have really long wait periods. So any other country that's not listed here basically follows this here, right? So as you can see, China is, consistent with this, but a country like Mexico, they're still working on F1 cases that were submitted in 2002. That means it's going to take a really long time. So F2A, which is green card holders filing for their spouse and children under 21, is current. So if you are a green card holder, you can file your petition without knowing that they're working on it right now. You're not going to wait for a priority date to be reached for them to continue for adjustment of status or consular processing. Now, F2B, pretty much, if you're not in any of these countries, they're still working on cases from January 2017. Same here for F3 2009 and F4 2007. This F4 is a category for brothers and sisters, US citizens filing for their brothers and sisters. That takes the longest. So let me give you a picture of what happened to that client that went from an F1 because their priority date was now current. Their father had filed maybe 5-6 years ago, and their priority date was now current, right? I'm talking about the consultation I had. And then when he got married, guess what? He bumped himself to this F3, married sons and daughters of US citizens, right? So that meant that basically he's going to have to wait until his priority date is reached because now they're working on cases from 2008. So that's a really expensive mistake to make because now you're just waiting when you could have been you could have come to the United States and now turned around and filed for your family. And so now with the immediate relatives, right, there's no derivation, there's no derivative application. What that means is that if you file for your spouse and your spouse has children who are under 21, you have to file a separate petition for each one of them, right? But on the preference category, which is right here, if you file for your children, say you're a green card holder filing for your child and your child has children, they are derivatives, they're included in the petition, right? Same thing for if you're filing for your married children, their spouse and your children and their children will be included in that petition, right? So that's why it's important to know when to file for your family member. So if you're a green card holder and you're married to somebody who has children, you might want to file while you're still a green card holder, right? Because that means, your spouse and their children under the age of 21 will come in, from the same application. Now, if you look at this preference, it tells you that if you're a green card holder, you cannot file for your parents, because I get this all the time. If you're a green card holder, you cannot file for your parents. I think that's pretty much what I wanted to talk about today. So let me check messages. Hi, Ahmed Gabber. Ahmed says, when I check my case status, it keeps saying, on November 22nd, 2022, we received your case and waived the filing fee for your I-360. I-485 and nothing else. Is this normal? That sounds pretty normal. Your I-360 fees are always, well, not always, but if you're filing VAWA, it's waived. If you're filing SJIS, is waived. The I-485 is not waived though, so your I-360 is waived, but unless you apply for some kind of waiver, your I-485, the filing fee is $1,225 for right now. But there's nothing there to panic about. Okay, Ahmed? So just, keep checking your case status. Okay, that's always a good thing. And Elijah says, hello, best attorney in VAWA. What happens if you don't get your prima facie and EAD after your biometrics? So Elijah, hi, how are you? So that's a great question. So how long have you been waiting for your prima facie? Because sometimes they take a little while, right? Now, if you haven't gotten it after maybe 5 months, what I do is I reach out to the VAWA hotline to find out what's going on, right? We've never gotten a VAWA that we didn't get a prima facie. So I don't. If you don't get a prima facie, it could be that it's just delayed, or it could be that they're not going to give you a prima facie. But in most cases, at least in our firm, we've had a couple cases where the prima facie took a long time to come, because right now we're getting prima facies really quickly, which was different from during COVID when things were pretty delayed. The EADs are still taking a while. It could take anywhere from 4 months to 10 months. So if you haven't gotten your prima facie, sometimes they just need a reminder. And if you have an attorney, they should, follow up with the Vermont Service Center, which is now Nebraska, because that's where VAWA is being filed right now. And typically when we do that, we get the prima facie. All right. So great question. I'm going to get out of this. Stop sharing. All right. So back on target. So guys, that's what I wanted to talk about, because, when you make these little mistakes, right, that cost you, it's so sad, because nobody wants to be in immigration court, right? It's so stressful. So if you found this information helpful, please share it. And if you found it helpful, please follow, and share. It's always important for me to bring this information about the things that you need to avoid, so that your immigration process is as straightforward as it can be, because the immigration process is stressful enough already. We don't have control over a lot of things. We don't have control over how long, to an extent, how long it's taking, because USCIS is so backlogged. But you want to make sure that you're not doing anything that's going to increase the backlog, stop you from getting your paperwork, or, God forbid, put you in deportation proceedings. So that's it for now. I hope you guys have a great week. Have a great weekend. I will be back next week. Take care.